You're sitting in your office, maybe late at night, or maybe you're even lying in bed and you can't sleep. And all you can think about is how the defense seems to be one step ahead of you in this litigation. They have more money, they have more manpower, and it's really frustrating you. What do you do? My name's Saul Gruber from Gruber Trial Consulting, and we help our clients with this very issue on a daily basis by something called a rabbit hole. A rabbit hole is where a lawyer starts to go down that rabbit hole of a particular issue that really has no relevance in the case. It could be an objection that was made at a deposition, and now motions to compel are flying back and forth, all for an issue that doesn't matter. So don't go down the rabbit hole, because that's exactly what the defense wants you to do. They throw so many things at the wall hoping something sticks. Meanwhile, you're defending them over here and over there, and you have no time to actually really prepare your case. Why not flip the script? Use the rabbit hole against the defense. Send them requests for admissions on an issue that may not matter in your case. If it's a motor vehicle accident, perhaps you're asking for the defendant driver's cell phone records. Now they'll come on board, they'll start filing motions, filing for protective orders. They're spending time fighting this issue, and you don't care about the issue. Another type of rabbit hole in medical malpractice cases, especially where hospitals are involved, is if you start doing some discovery for negligent credentialing. Now, granted, in some cases, that is a big part of the case, but in most it's not. But now you've got the defense talking to the administrator of the hospital. They're all getting worried. They're now spending time looking at and worrying about an issue that you don't care about. If it's a nursing home case, perhaps you are now asking for tax returns of individual owners of an LLC that is the actual owner of a nursing home. You may or may not be entitled to it. It's really not part of your case, as this is a first fall fractured hip. But the defense is now worried about something else, and they're filing motions. They're spending their time, their effort, and their resources on issues you don't care about. Because we always have to remember, anything you do, whether it be a deposition, discovery, or even evidence, must advance your story, must advance what you want to do in your case. If it doesn't, you're never going to use it at trial, and really, it's a rabbit hole. So now is the time, rather than get sucked into the rabbit hole, flip it, put the defendants in the rabbit hole, and that's where you, if you're a small plaintiff firm, can compete, if not win, the resource and the financial issues. If you like this tip, please hit subscribe to our YouTube channel. That will get these tips sent right to your email and easier to look at. Also, look, in the next 2 weeks, you'll be seeing our new podcast, The Jury Thinks What? We'll be dealing with issues like these with lawyers all over the country, just like you, who have issues and have learned some things in trying cases. And if you like what you heard, feel free to call us at 305-414-1600 or email me at saul@grubertrialconsulting.com. We're here to help you. And look for our next trial tip, which will specifically be about the use of interrogatories, when they're good, when they're bad, and why do you really use them. And stay safe.